All right, everybody, if I can have your attention. Thank you. That's why we have that. If I could ask Representative Byrd to lead us in a word of prayer.
Good afternoon. If we'd bow our heads, please. Dear Heavenly Father, thank you so much for this day that you have given us. Thank you for all those that are sitting here in this committee room to be part of the hearings about legislation that we're going to discuss. We thank you for all that is around us, and we greatly appreciate that there is justice and reform that can be done here in this committee room. Be with each one of us as we travel home and keep us all safe. In all these things we ask in Christ's name. Amen.
Amen. Amen. 80 years ago today, Marines landed on Iwo Jima, so if you would join me in a moment of silence and remembrance of all those Marines that we lost 80 years ago today. Thank you. All right, first up, we're going to hear from Representative Brad Thomas on House Bill 171.
All right. Well, thank you, Mr. Chairman, committee. I'm here to present House Bill 171. The latest LC number is LC 481500S. I just want to make sure everybody's got the right number in front of them. Obviously, we've had several conversations on this bill, and it's as it's worked through the process, we've made a really good bill even better. So part of that, we've added .1 to the 161280, which took care of the concern about the old version of 161280 that had some constitutional issues that had come up in that during that process. So that takes care of that, so that's no longer a problem. We added the language in, I believe now it's moved to lines, what is it? It's somewhere right around lines 100. Yeah, I'm sorry, it's 107. It's moved to 107. And that's just to make sure that we picked up the issue with making sure that there's no confusion that this is an enhancement to an existing sentence, it doesn't lower the sentencing. And because we moved, we created 80.1, Section 4, these are the pieces of code that reference the 80. And so we now call them out in Section 4, so that way it's hooked into the definition of obscene as defined in 80.1. And otherwise, I've presented the bill a couple times. I think everybody in here has heard me talk about it probably at, I won't say ad nauseum, but pretty close to it. So I'd be open for questions, Mr. Chair.
I don't have any questions yet, and I hate to, there was something that was brought to my attention. I think it'd be favorable to you. I hate to propose another change, but just, it's brought to my attention. I think you probably agree. We don't have a quorum, but we're listening. We're hearing testimony right now to get the process moving. What I will offer is a friendly amendment, and I hope you agree with me. After Georgia Bureau of Investigation on line 58 on page 3 of the bill of LC 48-1500S, I would add, I'd put a comma there after investigation and add National Center for Missing and Exploited Children.
I would consider that to be a friendly amendment.
Okay. I figured you would, but just want to make sure. What line is that? That would be line 58. I know I need to go see my eye doctor, so thank you for making sure. That's the only thing I had on an amendment.
Perfect.
Any other questions from members of the committee? Representative Byrd? Yeah, go ahead.
Thank you, Representative Thomas, for your bill, and certainly we want to do everything we can to protect children in the state of Georgia and, of course, across this country. So my question is, if there is computer-generated obscene material when no actual child is involved, is that going to face challenges for the First Amendment?
I'm sorry. Phrase that. Say that. Could you say that question again? I want to make sure I understand the context.
Certainly. So if there is a computer-generated obscene material when no actual child is involved, could this face the First Amendment?
Well, I guess my answer to you is, are you familiar with how they make that fake face, or not real face? Do you know how they do it?
I would assume it's off of a computer.
Well, it's off a computer, but do you know how they make it? Obviously, a computer has to be trained on what a child's face looks like. You know how they do that?
Please explain.
They take real kids' faces, your grandkids, and they use those images, and then they create that image from it. So yeah, I would say that that's not a First Amendment issue. So I hope that answers your question.
And then I have a follow-up question, please. So can you provide instances that AI has been used in such a heinous manner up to this point, please?
Yeah, I can. Actually, there was just a case in the state of Wisconsin where a man made 13,000 AI-generated images off of real children. This is a real case in Wisconsin, just happened. So it is actually disgustingly rampant across the United States.
Thank you.
Yeah.
And I believe there was a case in my home circuit over the last year because there was a conversation where I had it at the local parts store. There was a local deacon of a church that was found guilty of having these sort of generated images. And so
if you type in AI-generated child obscenities in any search engine, you're going to be shocked about how much news will come back about it. It's substantive. I mean, it's not. This isn't a one-off, two-off. This is unfortunately a very disturbing trend that's going on across the United States.
There's a lot of disturbing trends for sure. Thank you.
Yeah. Floor leader Hong.
Thank you, Chairman. Representative, isn't it true that obscene material is not protected by First Amendment, and we're talking about obscene material in this bill?
That is my understanding.
I don't see any others, so good job. That's the quickest you've ever had it in
Thank
here,
you.
Brad.
I'm going to head on to government affairs. I
right.
appreciate y'all very much.
Go straighten them out. All right. Let's see. Well, I can tell it's a lawyer with the handwriting. I think it's my DA friend. Somebody. Randy? Randy. Okay, all right. I want to make sure. Yeah, your intelligence shows in your handwriting, my friend. The sloppier, the smarter. Okay. I think that's. We didn't have anybody. We didn't have a. All right. I don't think I had anybody else signed up for this one, so thank you. We'll come back to this once we get a quorum. Next piece of legislation we'll take up is for the birthday boy. Chairman Werkheiser, House Bill 123. Happy birthday. What number is this?
Thank you. It's very simple. 1, 2, 3. ABC, but you may be too young for that lyric.
That
Was Jackson, Michael Jackson before there was it was only Jackson 5.
I guess before the legal troubles. Okay, well, not to speak ill of the dead, but facts are facts. All right, go ahead, tell us.
Well, thank you. As I said last time, this bill really signifies what we're here for, and that is wisdom, moderation, and my mind justice. Thank you. I'm going to give you the non-legal version because there's enough lawyers in this room to straighten me out. But Georgia is the only state in our nation that is executing those with intellectual disabilities. And we can fix that by doing two things. Number one, by changing the standard of evidence from beyond a reasonable doubt to a preponderance for evidence. That is a impossible hurdle to when you're doing intellectual disability assessment. The other is more of a it's a procedural to remove the decision if someone is intellectually disabled from the guilt phase of a trial to a separate hearing before. And the reason for that is this: someone is either intellectually disabled or they're not, and that's usually from, it's not something that grows on you, it's you're born that way. And so it's pretty easy to prove. The problem is if you do it at the end of a trial after a jury has seen 2 weeks of horrendous photos and images and stuff they wish they could unsee, it's hard to say that a jury would be unbiased and may want to up the penalty, or as I said, they either have ID or they don't. And so a pre-trial motion, either by a jury or a judge, would make that a separate issue, and then again change the standard. And that's the two things that the bill does.
Okay, thank you. And is it not true that you've actually been to Jackson and witnessed an execution?
More than one. And, well, somebody said why. So, if you know a little bit about my background, I think I'm the only legislator, past, present, or future, that has been to every prison in the state and spent a half a day inside every one of them. And because of that, during that year and a half, Department of Corrections invited me. I've been on the SWAT, where they do the sweeps, where they come in and turn the prison upside down. I've got a bag full of shanks in my office made out of, one made out of hundreds of Jolly Rancher wrappers melted down with a quarter with 2 wires stuck into a socket. I was just part of Department of Corrections for years, just doing, as a legislator, not as a job, just doing everything and wanted to be involved, and that was part of the process. I've spent a full day at pardon and paroles, learning the process from the time someone gets arrested to the full adjudication. They've got a timeline that would wrap all the way around this room of what that process is. It's complicated. So just learning and being part of the process.
Thank you for that. I would be remiss if I did not recognize my favorite judge in Douglas County, Judge Cynthia Adams. It's so good to see you.
Thank you so much. Thank you so much. Good to be here.
Thank you for being with us. My district attorney, elected district attorney, Mr. Randy. What county is that again? Newton and Walton. Newton and Walton, a 2-county circuit. Gotcha. We just created one of those over in our area as well. I'm sure you heard something about that. So good to have y'all with us. Did I miss anybody? All right.
Judge Taylor here from Dublin as well.
Judge Taylor from Dublin, thank you for being with us. Good people down there. Got a good tractor salesman down there that I can hook you up with.
It's the girl we've been waiting on.
And our fine Gwinnett Celestra, whom I met earlier. Good to have you with us. I know y'all got good staff to be here today, and trust them to keep on carrying out justice. So thank y'all for that. Okay, we've got quite a few speakers on 123. Just going to ask you, I know I was not here when this bill was heard. I was watching from the hospital room, but thank y'all for testifying before. So if you've testified before, I'll put you on the honor system. Just, keep it as succinct as you can. It's not Groundhog Day here, despite what you may see here every day. So any questions from the committee first? I see none. I know we've had this bill 2 or 3 times in the committee, so thank you, Chairman Werkheiser. We'll move on to testimony.
You want me to move? Then we'll come here?
Just scoot over. So I don't think anybody can throw a punch, but you distance yourself. All right. Michael, and I'm sorry, I can't read the handwriting that well. Yes, how do you pronounce your last name?
Admirand.
Admirand, okay, I won't forget it. Michael, good to see you again. Tell us who you
Good to see
with.
you. I'm with the Southern Center for Human Rights.
Okay,
And,
go ahead.
And congratulations, Chairman.
Thank you. Appreciate that.
And happy birthday, Chair. I'm trying to speak on behalf of the Capitol Defense Bar. It's not an easy thing to do, but I will do my best. I want to thank Chairman Werkheiser, all the sponsors of this bill. And as you said, Chairman Smith, we've been at this for a long time, and I appreciate the work of this committee on this issue over the last few years. I'll try to keep these remarks brief so that I can answer any questions, and I've tried to confine my comments that they're responsive to what happened a couple weeks ago. But before we dive into the specifics, I do just want to take a step back regarding the impact of this bill. It's very important, but it's also very, very limited. According to the Georgia Department of Corrections, there have been over 150,000 people convicted and sentenced to prison terms in the last 10 years. About 3,000 of them were for homicides. And in that same time period, there have been about 90 death notices in the state. So we started at over 150,000. We're already down to just 90. And even of those 90, only about 10 of them claimed ID. So really, we're just talking about 1 or 2, maybe 3 cases a year. Of course, it's extremely important that we fix the problem for those cases, because the Supreme Court has said that people with ID face a special risk of wrongful execution. But we're talking about a tiny, tiny slice of Georgia's criminal justice system, and a tiny, tiny slice even of Georgia's death penalty system. And so I just want to keep that in mind as we talk through the impact of this bill. Now, turning to the language itself, there are, of course, 2 important changes, as Chairman Werkheiser laid out. It would change the standard of proof to from beyond a reasonable doubt to preponderance of the evidence. And it would separate the ID determination from the guilt phase of the trial and give the parties the option to have a pretrial hearing on the issue. I won't spend a lot of time on the standard this time because a couple of weeks ago the prosecutors said that they support changing the standard to preponderance of the evidence. That's very important, but it's not enough to fix the problem. Here's how I think about it. If the clock's running out and you're down by a touchdown, kicking a field goal is not going to help you. You're still going to lose the game. And the score looks a little better, but you haven't tied it. And that's all we're trying to do with this bill, is tie the game. And to do that, we have to change the process. Under current law, the jury makes 2 decisions at the same time, whether the person's guilty, whether the person has ID. And this bill separates those 2 decisions. And that's important because the U.S. Supreme Court has said so. A few years ago, they considered how Texas handled intellectual disability. And one of the things Texas did was they asked jurors to look to the facts of the crime and consider whether the crime showed evidence of planning or forethought. Basically, they asked jurors to think, do you think someone with ID could have done this crime? And the Supreme Court said, you can't do that. The facts of the crime and the question of ID are completely separate questions. Putting them together like this, and here I'll quote from the Supreme Court, creates an unacceptable risk that persons with intellectual disability might be executed. So in other words, if you separate those 2 decisions, you make them more accurate, and you lower the risk that someone with ID will be executed. And this just makes sort of common sense. The guilt phase of a capital trial should be focused on one question, whether the person's guilty. ID, that's a sentencing question. It's not a guilt question. Regarding the optional pretrial hearing, which is in lines 13 through 34 of this bill, and I don't think there's been a new LC, but I'm just for the 1378. A couple of weeks ago, it was suggested that the pretrial hearing would grind capital cases to a halt, lead to endless litigation, and that's just not the case. First of all, and this is important to emphasize, it's optional. Lines 19 through 22 say that the state can object to it, and the court can decline to hold it. So some of you might think, it's probably better for a jury to decide this. I think a lot of judges around the state might agree, and so they would just decide not to hold a hearing. So we want to let this go to a jury. This pretrial hearing is only mandatory if the state agrees to it. And there might be cases where they want to, as they've said to me privately. Maybe they want a preview of the defense evidence. Maybe they want to see how their expert holds up. Maybe it helps them in their negotiating posture. The point is that we're just trying to give the parties an option. And it's not slowing anything down. Capital cases have scores of pretrial hearings. They take years to bring to trial. There's a pretrial hearing on everything under the sun. Forensic evidence, jury panels, witness statements, you name it. This is the one issue where you can't even have an option of a pretrial hearing. And it just doesn't make sense. People with ID are entitled to more protection, but we're providing them with less. And it's just not efficient either. A pretrial hearing, when it happens, can simplify the case and save the state the expense of a capital trial and the appeals that would inevitably follow. Regarding those appeals, it was said that this would lead to endless appeals. And I thought Representatives Kendrick and Panage put this concern to rest. But I do want to add one clarifying note. Lines 33 through 34 do authorize a pretrial appeal, which would be new. But we added that at the request of the prosecutors when a similar bill was introduced last year. The only new appeal in this bill, in other words, is for the state. Everything else the defense is going to do no matter what if this case goes to trial and results in a death sentence. A couple weeks ago, nobody came here and said this, but I do want to address it because I've heard rumblings of it in other conversations regarding the retroactivity of the bill. This bill would not apply to anyone on death row. Line 108 explicitly says that the bill applies to cases that go to trial, quote, after July 1st, 2025. The Georgia Supreme Court has already held that changes to Georgia's ID procedure don't apply retroactively. Now look, might somebody on death row try to file something and say it should apply to me? Sure, maybe. But they would lose because the text of the law, the case law, they're both clear. And if anyone comes up behind me and says anything to the contrary, that this is going to open up death row, everyone's going to get off, please ask them to tell you what the case is that says that will happen. Because I don't think it exists, and it's my job to know if it would exist. The last thing I'll say before I take questions is D.A. Barksdale said recently that Georgia has never executed someone with ID, and we can debate that until we're blue in the face. I think the question for this committee isn't whether or not we have. It's whether there's too high a risk that we will. And this bill would ensure that we don't. Thank you for your time. I welcome your questions.
See no questions from the committee. Thank you for being back with us.
Thank you for having me.
All right. All right. Frank McCaughey.
Chairman, if I could, I'm going to ask if we switch Ms. Dinsmore.
Sure.
A lot
Sure.
of good
Charlotte
information,
Dinsmore.
And we'll come up after her to sort of fill
Okay.
in.
That sounds good. That's fine.
Very knowledgeable.
That's fine.
In this area.
Charlotte,
Very
you'll just
kind.
tell us who you will.
Hello, good afternoon. My name is Charlotte Densmore. I'm here on behalf of the Georgia Council on Developmental Disabilities. It's good to see some familiar faces here today. We are here to support House Bill 123. We are a state agency at GCDD whose mission is to advance the rights and opportunities of people with intellectual and developmental disabilities across Georgia. While developmental disabilities encompass a broad range of conditions, intellectual disability is a very specific diagnosis that affects less than 1% of the population. Intellectual disability refers to significant neurodevelopmental conditions that affect functioning in two areas: cognitive functioning, such as learning, problem solving, and judgment, typically measured by an IQ score below 70, and adaptive functioning, activities of daily life such as communication skills and social participation. I want to be clear that the Georgia Council on Developmental Disabilities does not have a formal stance on the death penalty. We support this bill because it will bring Georgia in line with other states' standards of evidence for determining that an individual has intellectual disability. This bill is important because just last year, the state executed an individual with an IQ of 68. I appreciate the opportunity to provide context on intellectual disability today in support of this proposed legislative change, and I welcome any questions. Thank you.
See no questions. Thank you very
Thank you so
much.
much.
All right, Frank, your turn.
Mr. Chairman.
Yes, sir.
I'm Frank Mulcahy. I'm Executive Director of the Georgia Catholic Conference, and I will be very brief. I have with me Ms. Maggie Rousseau. Maggie has a lot of knowledge of intellectual disability. She is the Director of Disability Ministries for the Catholic Archdiocese of Atlanta. Simply, I'm going to say that we support this bill because we try to support any legislation that recognizes the dignity of every human being, whatever their race, their color, their nationality, their intellectual abilities, whatever they may be, the human dignity must be preserved, and I think this bill moves us in that right direction. As I said, Maggie knows a lot about intellectual disabilities. If you have any questions for me or for Maggie, we would welcome them.
Maggie, do you have anything you want to say?
I would just say from a practical standpoint, I am a mother of a child who had intellectual disabilities. I've been in the disability world for 34 years as a parent, as a special education teacher, getting my degree from Georgia State, and also then as an advocate. And you know, when I first learned about this law, I come from a family of lawyers, but I'm not one. But when I first learned about this law 10 years ago, I was absolutely appalled. And I just see us as being better than that here in Georgia. Having lost my son, I understand the loss that the victim's family feels, and we in no way diminish that loss. It's a terrible tragedy, but at the same time, I cannot understand how taking the life of a person with an intellectual disability is right. I think part of what's happened in past sessions has been just understanding intellectual disability. Is it something that can be faked? Is it something that someone can have, I think the legal term is a moment of lucidity. And that is not the case. It cannot be faked. And this is not a legal term, but it's the brain has an injury as a result of either a genetic disorder, something that might have happened at birth. There's a myriad of reasons why intellectual disability could have happened. I also, you know, I see the faces of the people who this bill would protect. Many of them are and were in class with my son. They look like us, right? You can't tell someone has a disability, an intellectual disability most often. And so it really comes down, as we see it, that it's about protecting the person with a disability. It's about being aligned with the Eighth Amendment for cruel and unusual punishment, and it's also about just the dignity of the human person. And I would ask you all to please look favorably on the changes that have been proposed. I think this is our cleanest legislation yet. And I thank you for your time, and we'll take any questions.
I don't see any questions from members of the committee. I do have one question. I know we've been praying for Pope Francis. I understand he was in the hospital. Is he out, or is he still receiving care?
Last I've heard, he's still in the hospital.
Okay. All right. We'll continue to pray. You had a question come up while we were here. Number 14, Representative Byrd.
Yes, thank you. I was just talking to Chairman Gunter here. Could you give us a definition of ID, please? I mean, who fits into that category?
I can.
Thank you.
And so basically it's, let me pull that back up. It's persons who have both been diagnosed and identified before the age of 22. So that's part of the rule. They are persons who also, let me go back to this, they could have developmental disabilities, learning disabilities, social and behavioral problems, and those are classified as adaptive skills. You know, skills that are areas where we might, I'll just use a young man I know, he got in trouble with the internet, and serious trouble with the internet, but he didn't know what the other people were coercing him to do. And he's diagnosed with intellectual disability. There are many tests that an individual would take that would be given by a psychologist or a psychiatrist. And those are standardized tests that are accepted nationally. And, you know, those define what your IQ is. So an IQ under 70 is considered a person to have an intellectual disability. In my son's case, his IQ was 44. So we often find that someone can do basic things like get a driver's license, hold a job, but still have problems when it comes to maintaining relationships or wanting friends so badly that they go along with suggestions from people. They might not manage money well. They might not have support at home, you know, or in the community. You know, they're left to be alone. So although we do, my experience in the Department of Education in Gwinnett County and also in Effingham County, we do a really good job of trying to help someone be successful. But it's when they don't have those supports out in the community that problems happen. And I would like to add too, just you having your new son, congratulations. There's such a disparity in the state when it comes to identification of, say, genetic disorders. Fragile X syndrome is the most prevalent genetic disorder that causes intellectual disability. And I can imagine the frustration of those parents knowing how long it takes to actually get a diagnosis for us, and I'm somebody that didn't take no for an answer. So other people that don't know how to go through that process are just going to keep saying, oh, well, we'll help him pass. We'll help him be able to do this in class. We'll help her to, you know, move up to the next level. And so I worry about the people in rural areas that don't have access to services like we have here in Atlanta.
I think if you'll look, line 15 of the bill references Code Section 17-7-131. Intellectual disability means, this is reading from that code section, I believe that it's referencing. Intellectual disability means having significantly sub-average general intellectual functioning resulting in or associated with impairments in adaptive behavior which manifested during the developmental period. That's the definition. So.
And the developmental period was from 22 early.
Yeah.
Yeah.
All right. Okay, no other questions. Thank you all very much. And thanks for the update on Pope Francis too. All right. Let's see. Russell Gabriel with Gactyl.
Thank you.
Welcome.
I'm delighted to be able to be here today and speak for a moment. My name is Russell Gabriel. I'm a criminal defense lawyer, and I've been practicing criminal defense in Georgia for around 35 years, something like that. I live in the Athens area. I was here a couple weeks ago, and I believe that the prosecution mentioned that there had never been a case in Georgia where during the death penalty trial a person had been found by the jury to be intellectually disabled. And with all due respect, they're wrong. I think the general sense of that is probably correct. But there is at least one exception, and that was a Clark County case, 1999, a woman named Vanessa Marshall. The jury found Miss Marshall, beyond a reasonable doubt, to be intellectually disabled. They also found her to be not guilty of malice murder, but guilty of felony murder. I represented Miss Marshall in that case. I was the lead counsel. Anthony Pete was co-counsel, and he stepped out in the hallway, but today I realized that Mike Mitchell, our investigator back then, is currently the bailiff for this room, or he's here today. And I hadn't seen him for a long time. There he is. Yeah.
My former boss. He just called you our bailiff.
I don't know.
I was his investigator.
I wasn't sure. Yeah. It's a delight. It's a delight to see him, for sure. We prevailed on the intellectual disability portion of that case because the evidence was just so unquestionably clear. Ms. Marshall had her disability been recognized by the Clark County school system. In 3rd grade, in 6th grade, and in 9th grade, she was given a standardized IQ test, and in each instance tested below 70. That general cutoff that was mentioned just a moment ago. After she left school, she had 2 additional IQ tests for various reasons, and in both of those also the result was less than 70. There was also other evidence supporting that conclusion, but nevertheless we went to trial on that, and it's hard to know what better evidence of intellectual disability a person could have, I think, as evidence to use on their behalf in the context of a trial where you're trying to prove it up. But I don't mean to make it sound easy. Every step along the way in that trial was a fight. Prosecution fought very hard to attempt to prove that she was not intellectually disabled. The trial was not only a fight, though, it was also just sort of a mess. And that's the part that I wanted to emphasize and partly why I'm here. And it was a mess because of the fact that you have these sort of 2 trials occurring at the same time. Right? All of the evidence about intellectual disability comes in at the trial in chief, as well as the state's evidence of guilt or innocence. Right? These are not bifurcated, they're not separate. All of that's coming in at the same time, and they relate to 2 different issues. And the disability evidence is not necessarily relevant to the homicide charge, okay? And vice versa. So the jury's receiving it all at the same time, and the lawyers are sort of having to think about all at the same time as well. In spite of the best of jury instructions that our judges may give, I think it was difficult, or a judge in that case, it's difficult for the jury to appreciate that a major portion of the evidence they've heard on one thing is actually irrelevant to some other thing. Right? I'd also say this, that in the heat of a death penalty trial, an issue can get lost. And which issue is it going to be? You know, if you think about the evidence in a homicide, the emotional content is great, is significant. And the evidence in general can be fascinating for jurors. The evidence of intellectual disability, it kind of can get lost in there. It doesn't move jurors in the same way. And trials have a sort of emotional tenor that can go back and forth, where people zoom in on something and then it changes and things shift and it's not as interesting. To put those things all together into one trial is just a sort of a mishmash. And so the part of HB 123 that changes procedure to allow for a pretrial hearing, I think would be a wonderful thing if that in fact happens, and as is mentioned, it's not a guarantee, but that's one of the options that's available under the revised procedures. It also lays out a separate procedure for determining intellectual disability in the event the case goes to trial, and that would have a bifurcated process where decision on guilt, innocence, and all the evidence, that trial is heard first. The same if they return a guilty verdict, the same jury hears the evidence of intellectual disability and makes an independent decision. But at least that procedure even recognizes that these two things don't go together very well. So I'm just here in support of the bill. I think that it will increase the accuracy of the fact-finding in intellectual disability cases where the death penalty is at issue. And I also think it's just more efficient. In the event the judge does find at a pretrial hearing that the defendant is intellectually disabled, if the state does not appeal it, and that appeal is not granted because it's discretionary, then the death penalty is off the table at that point. That trial turns into a regular homicide case, difficult enough, but there is so much less sort of going on in a regular homicide case compared to in a death penalty case. So there's some tremendous efficiency that's built in there as well. I'll rest on that. I'm happy to answer questions if there are any.
I don't see any questions from members of the committee. Thank you for taking time out of your practice. I assume you're still practicing.
No, I'm trying to practice retirement now.
Not a bad idea. Not a bad idea.
It's a work in progress.
Good. All right. Okay, let's see. Let's go with Randy. Is that McGinley? Yes. Welcome back.
And to take my name is Randy McGinley. I'm the DA in the Alcovey Circuit, which is Newton and Walton County. And to take the chairman's statements at heart, I'm not here to rehash things that District Attorney Barksdale and Sheila Ross testified to previously. Frankly, they have more experience in trying death penalty cases than I do. I think my purpose today is mostly to speak about, I know from meeting with Chairman Wickerheiser before, virtual calls, and previous meetings and previous hearings about this bill, this Young v. State case has come up numerous times. And I think some context in that is I was the DA who actually handled the appeal. I didn't try the case. My predecessor in the DA's office tried the case, but I handled the appeal on that. And so, as I said, I don't want to rehash things, but I think it's important to say that I agree with DA Barksdale and Sheila Ross on a lot of their takes on this bill and the issues that it would cause. But I want to talk just a little bit, because everybody's sort of been, Rodney Young's been a little bit of the individual that people hang their hat on for the purpose behind this bill to a certain extent. And I wonder how many people know that Rodney Young went to college, that Rodney Young did not call expert witnesses at trial on his own behalf because his IQ was 77 by his own expert. And so a lot of where this bill comes from this impression that Rodney Young is somebody who is not what he is portrayed for by a lot of these people the proponents of this bill. These are cases that involve, and I understand all these cases are terrible things. I've seen a lot of horrible things over the last 13, 14 years. The Rodney Young case is probably at the top of the list of those things. Someone who staged a crime scene after brutally murdering his ex-girlfriend's son, grown son, adult son, knowing that his own mother would come home to find him. And seeing what the back end of a claw end of a hammer can do to someone's head and neck is horrendous. It is absolutely horrible. All this by somebody who does not meet the definition of an intellectual disability, even by his own experts, yet this is something that we still have fighting about whether or not he is intellectually disabled to this day, even after the appeals are over. The current standard was upheld by our Supreme Court. They sought to take the case to the U.S. Supreme Court. They said they weren't even going to hear it. It's because Georgia law currently is constitutional. It works fine. It works well. And I think changing it, again, I'm not going to get into that. That's already been testified in previous hearings by D.A. Barksdale and Sheila Ross, who, as I said, have vastly more experience in that than I do. And I'll leave their opinions on that, and I agree with their opinions. But I just want to make sure that this panel and other people understand the case that really brought this. It was a single dissent by a judge, the Supreme Court, led to a lot of this, and that's what I've been told by people that brought this bill, that's the reason behind why this bill was introduced. And so I think it's important for everyone here to understand, why we are here, and what that case was actually about. As I said, I support what they've said before. I think if as district attorneys, our job is to follow the law. If there's available punishment and it's appropriate in that case after reviewing the facts to seek that, even the most severe punishment, then it's our job to do that. You guys pass the laws. We uphold those laws. That's our job. But if we're here to make the death penalty something so unmanageable to even seek, then, as they said before, then just repeal it. Make it not an option. But I'll answer any other questions if anybody has any questions.
I don't think this bill does away with the death penalty as a whole. I think it aims to do away with it for those with intellectual disability.
Well, I'm not saying it does that. What I'm saying is I think from what D.A. Barksdale and Sheila Ross testified previously, I think their concerns is that it makes it so unmanageable that it essentially will do that without explicitly actually saying that in the bill.
Okay.
That's what they testified to in the previous hearings.
Okay. Number 17. So, Chairman Leverett.
Yep. Thank you, Mr. Chairman. Thank you for your testimony. I did want to go back to that question because my understanding is there's sort of two general objectives with the filing of this bill. One is to change the standard of proof, and two is to change the procedure.
Correct.
And the testimony we heard from prosecution side at the last hearing was there isn't a lot of objection on your side of the aisle or of the courtroom with changing the standard of proof, but there is a big concern about the procedural changes made in the bill.
Correct. I'll get close to the microphone. I should have been more clear on that. That is correct. I think we had discussed, not necessarily in the committee, of us coming to that agreement with that change, and I think that didn't happen. But I think you're correct. As far as that portion of the bill, that's something that I think we can live with. It's a procedural aspect that is a bigger objection from us.
So to just kind of drill down a little more into that. So this bill changes the standard of proof. The burden is still upon the defendant. The defendant has burden of persuasion and production to demonstrate intellectual disability, and here they would do it by a preponderance of the evidence. So my understanding, because I don't do any criminal work and I certainly don't do any capital criminal work, is that currently the defendant has the burden of production and persuasion, but they have to prove by, I can't remember if it's clear and convincing or beyond a reasonable doubt.
It's currently in Georgia beyond a reasonable doubt.
Beyond a reasonable doubt.
Correct.
Okay. So at least as to I'm looking at lines 25 through 27, well, really 25 and 26 of the bill, that portion of it, you at least personally would not object to. Is that correct?
Correct. And I think that I recognize obviously that Georgia, I think we were the first state that actually made it to where people with intellectual disabilities could not be executed, but that our standard is different than other state standards. And so I understand that.
We're somewhat of an outlier,
right,
is my understanding on the standard of proof. Okay. And the bill then goes on to say, and I'm sort of getting into a legal issue now that I'm trying to understand, if the pretrial determination does not find the defendant to have intellectual disability, he or she shall not be precluded from raising such issue in further proceedings. And I think there was some testimony, I don't remember the young lady's name, that the defendant can raise it in mitigation, but they could not continue. My understanding was that the defendant, I think the prosecution position was they could be raised in mitigation at sentencing, but you could not, as a defendant, continue to argue about the presence of an intellectual disability otherwise in the trial.
That's not necessarily my, and maybe I'm correct me if I'm wrong, but my reading of it is that you can have the pretrial hearing for the judge to determine whether or not somebody meets the standard of intellectual disability. If the judge says no to that, you still can raise it under this bill. You still can raise it at the trial level in what this bill would make. I don't know if trifurcated trial is an actual term, but we'll call it that. And then again, it can be raised in the mitigation in the actual sentencing phase to where a jury can not give a death sentence for any reason, which I consider is also includes no reason whatsoever. Just, any reason at all, including, even though they may not find someone intellectually disabled, they may think, for instance, it's so close that they don't want to give someone a death sentence. So I think under this bill, in that light, it's essentially 3 bites of the apple with it.
Correct. And that is my understanding. And I'm curious, currently, the issue is raised at the trial before the jury on where you're also considering just general, guilt or innocence in the sense of did the defendant actually commit the crime with which he or she is accused, and then the jury is also considering the issue of does the defendant have an intellectual disability that would preclude, a death penalty.
Right.
Okay. And I guess, and I'm sorry for that lengthy laying of foundation, but so what I'm trying to get at is, in your mind, is there a constitutional mandate that would require the defendant to be allowed to continue to raise that repeatedly through trial, or is the constitutional limitation more limited?
I guess my take on that would be, I don't think there's anything limiting the if I'm understanding your question correctly, I don't think there's anything in the Constitution that would preclude the defendant from continuing to raise that throughout the entire trial. I mean, by the time, so it's the same jury that considers all of these things, and they're not told to forget what they heard in the other stages. Mm-hmm. And so everything's sort of, especially in the sentencing phase, I mean, they can consider what was said in the phase before the sentencing phase. And so I don't think anything in the Constitution precludes them from continuing to raise it throughout the entire. Well, is that what you're asking? Or?
I'm not asking. Well, sorry. What I'm asking is there anything in the Constitution that would preclude the state from saying, you get to argue this issue, and then once it's decided, you can't keep arguing it repeatedly. Because one of the issues I had with the bill as drafted is it seems to allow the defense to continue to raise the issue, whereas the state only gets one time to prove it or to disprove it, and then they're done.
Right. So I guess the question is there anything that allows the state to argue that the jury should not be able to consider those things multiple times?
Or that allows the state to craft a law which would provide some kind of issue preclusion on it? Because my understanding is there's a concern that the state may not constitutionally prevent someone in a death penalty case from arguing something like intellectual disability repeatedly in different facets of the trial. At least that's the vibe I guess I've gotten, or the sense I've understood.
I'm not aware of any state that has a law that says the jury can't consider the evidence from the prior phase. And so I don't know if I can answer if there's anything in the Constitution that would allow that, because I don't think that's ever been tested. I don't know. As far as I know, with the other states, when they have the different phases, you can still consider all of the evidence, and whatever happened in the first phase, you can still consider the evidence in the second phase. If the state precludes that through some sort of law, I don't know, honestly. As
a prosecutor, what would be your view of a statute which, because right now we take the issue of intellectual disability away from the jury, if I understand. I'm sorry, this bill, is my understanding, would require that to be determined by the court in a pretrial hearing.
I think it's one of the options that they have. Unless I'm reading this wrong, I thought they still had the opportunity to raise it at a jury trial as well.
Well, I would agree.
Yeah.
But presumably the pretrial hearing would have some impact.
Well, so let me give you an example. If someone files a motion for immunity based on self-defense, the judge determines that. That does not preclude the defendant from raising that same issue in front of the jury. So the jury still has to find that it was not self-defense.
So what is the function of having it just gives the defense one chance to take it out of the case altogether?
Correct.
Okay.
It's a pretrial determination by the court.
And I think to maybe aid in this, if you lose on immunity, you go for jury nullification from the defense standpoint.
Okay.
And I guess another example would be if the state wants to use a defendant's statement, the state has to prove the statement was voluntarily given. The court can make the determination. The jury still is instructed that they should only consider statements that they believe were voluntarily given. And so the jury could disagree with the judge on that in that situation.
Okay. So, and I'm about done, Mr. Chairman. I appreciate the chair's indulgence. I guess what I was trying to maybe find out in not terribly artful way or quick way was it relates to my understanding of the prosecution's objection to the bill, which is mainly the procedural changes it proposes to make other than the change in the standard of proof.
Correct.
To establish intellectual disability. And I was trying to find out if there was some part of the procedural change that either you individually or the community of our prosecutors would find workable or agreeable. In other words, you don't like the bill as it is. Are there some parts of it other than the change in the standard that would be, in your view, useful or workable?
I guess that's hard to answer without knowing what those specifics are and be able to digest those. I think that's where, again, I'll kind of go back to what D.A. Barstow and Ms. Ross have testified to previously, because I think they just, again, have more experience in this than I do, that they firmly believe that it's not workable under this bill. And
that's my understanding, and that it would do away with the death penalty effectively, and I'm still having a hard time understanding that statement or comprehending exactly why they hold that belief. So that was, and I apologize for asking you what they thought. That's okay. Not very fair of me, but I appreciate your effort to address my questions.
Yes,
Thank you. Thank you, Mr. Chairman.
Number 13, Majority Leader registration.
Thank you, Mr. Chairman. Thank you, sir, for your testimony. I just want to, kind of along the lines of Chairman Leverett's questions, I was not in previous subcommittee. I came in late today. I'm sorry, but I just want to make sure I understand the procedure. So the defense attorney would file a notice of seeking classification with intellectual disability, potentially pre-trial, and then the court would sit as finder of fact, hear the evidence, and decide whether the court wanted to grant that motion. If the court denied that motion, then there would be a jury trial, and the jury would first sit. That's the bifurcated trial you were talking about. The jury would first sit to determine guilt or innocence, and if a guilty verdict was returned, then there'd be a second phase to that, which would be determination of whether the burden of proof has been met to show intellectual disability. A jury determined that, and then I guess there'd be a sentencing phase at some point in there. Is that
right? That's why I kind of called it trifurcated trial. So yes, there would be that pre-trial motion, and then the three-part trial, which obviously, I guess there's obvious. I mean, if you don't get in the bill, if you don't get past, if they're found not guilty, obviously it stops. And obviously, and then the second phase, if they're found to be intellectually disabled, my understanding of the way this would be is that there then would not be a jury determination of the sentence, because if they're found intellectually disabled, that kind of stops that.
At any point, I guess, in those phases, if the judge or jury found a certain way, then that would, obviously, the death penalty would not be an option. It sounds like it's just right. They would have to
obviously
make the
if they're found not guilty, obviously,
of course,
they're not. But then if they're found intellectually disabled, then death penalty is off the table
right.
At that point. I don't know if off the table is not the legal term, but yeah.
Okay, so then I guess my question is along the lines of Chairman Leverett's. I guess you as a district attorney, or you as familiar with this issue from discussions within the Prosecuting Attorney's Council. Why is it that there is a contention that this new, I understand you may feel that the existing framework is constitutional already, but why do you think that this would have a negative impact on enforcement or following existing Georgia laws to enforce sentences where it's appropriate to do so?
And I'll give a couple of my reasons. I think I'll obviously what Dia Barstow and Ms. Ross said previously, they probably explained it in a better way than I can. But what I'll say is to a couple things is, one is the amount of time just in general that these cases take. And with this, with the pretrial hearing, the judge hearing, under, I guess it's lines 33 and 34, they can seek immediate review for that.
Sure, I saw that.
And the reality is, it goes straight to the Supreme Court because it's a death case. That's going to take another 18 months on top of, and then start everything over. And when you do that, part of any death penalty litigation is going to be some challenges to the jury pool as well. Well, depending on when that comes back from the Supreme Court, if it comes back in, near the time when a new jury list is coming out, you're going to have to wait for that new jury list to come out. And I don't know how judges would handle it if they'd handle this last. That would probably be the best thing of any pretrial motions, is go through all the pretrial motions and then have this last. Because if you don't do it that way, you could possibly have another interlocutory appeal, which would mean 2 interlocutory appeals before a case even gets to trial, which is, I think, should be frowned upon. Frankly, that just delays things. And then that's after you have that, and then all of the other steps. I think it's just, it is continuously adding more and more steps to a process that was already overwhelming and lengthy, and with numerous built-in safeguards for defendants. And these are all cases, even to get to this are cases where the DA's already had to make the decision, often after being presented with evidence from the defense, that they still want to go forward. I'll give you an example I've had in my jurisdiction just probably 3 months ago. The Capital Defender's Office presented me evidence of one of the individuals we sought the death penalty against, of her IQ scores when she was in middle school. And they were low enough. I took a look at it, reviewed all of it, and made a decision to not continue to seek the death penalty, and we worked out a guilty plea in the case. And so a lot of this are things that are way down the road after already 2-3 years of the case pending. And my concern is these cases are going to then be 7, 8, 9 years before the case gets to trial. And that is...
Mr. Chairman, if I may, I just have 2 final questions, just because I don't know the extent of the process currently like you do. So it sounds like the judge deciding, considering this, whether intellectual disability is in play, is an additional hearing that's not occurring right now, which would be subject to immediate review by the Supreme Court. Is there any, under the existing system, are these other phases subject to immediate review?
Right, so there's the unified, the UAP, the Unified Appeal Procedure for death penalty cases that we have to follow, that, for lack of a way to put it, there's literally a checklist of things to be reviewed. I guess that the defense should review. They may not raise all the issues. There may be things that aren't worth even raising. And all of those issues are to be, if it's motion to suppress, other issues, litigating jury lists, things like that. All of those are done, and then the judge can make it, if the defense seeks to appeal any of those things interlocutory, meaning pretrial, the defense can seek that, and the judge has a decision whether or not to send it up or not.
I see. And so, am I right then in concluding, or my understanding then is, we're really talking about one additional hearing, which would be subject to immediate review by the Supreme Court. That's the only addition that we're putting in procedurally here.
At the pretrial stage, I think that's correct.
Okay. All right. Thank you for helping me to understand this. Yeah.
Thank you, Leader F. Stration and Chairman Emeritus. Always glad to have y'all, have you with us. And thank you. This bill didn't come about because of good prosecutors like you. And so I understand, I appreciate that. Number 14, Representative Holly, new member on Judiciary Non-Civil. Welcome.
Yeah, thank you.
We'll have the pinning ceremony. Don't worry, it's not going to be anything like fraternity pinning. So.
Oh man.
Yeah.
Well, thank you, Chairman. New father, and I'm a baby on this here community. This is committee. Thank you for explaining that. So, just so that I'm clear, in order for this bill, in your opinion, in order for it to be, maybe if it was perfected, no, that's not before us, but just asking out of curiosity, if it didn't have this trifurcated part, but instead if it was more bifurcated, so that there was at least some level of a determination of ID before in the pretrial state before it goes to, up to Supreme Court. Would it be is that kind of what your contention might be, that because there's too many reviews, if it wasn't a 3-part and made it 2-part, it would be better?
I guess my stance on it is the current state of procedurally, the way it is handled currently is appropriate and has been found to be constitutional by the Georgia Supreme Court.
Yeah. And just further, but because these cases are less than 1%, about how much time would it take if you had so many other cases on the docket? This would be, I guess, if this would pass, and it would create that, I guess it would be a holdup and that review. Is your contention that this would actually add so much more time away from so many other cases, even though, an ID case might be less than 1% of the overall cases you would get to prosecute?
Right. I mean, in general, obviously murder cases in general obviously take more time than a lot of other cases, and the death penalty cases take, exponentially more time than even other murder cases. And so, ultimately, anything that takes more time is going to take time away from other cases. We have a limited amount of resources, and that is always a concern.
Okay. Thank you.
See no other questions. Thank you.
Thank y'all.
All right. Moving along. Maisie Lynn with Gactyl.
Thank you, Chairman. I will be brief. I did testify at the subcommittee hearing, but I would like to just address a few things that have just come up in the conversation you were having with D.A. McKinley. One is, when we have discussed the Young case with you and with anyone else who is interested in this bill, it has not been on the merits of Rodney Young's ID claim. We have never once broached the validity of his ID claim. That's not the point of that case. The reason why we bring up the Young case is because that is the case that the court signaled to you that you should pay attention to this piece of our code. In Bethel's dissent in the Young case, that's when he called out the potential problem with our standard of evidence in these cases. So just to be clear, no one has ever tried to argue anything about Mr. Young's ID claims. We just have been taking that case as the direction to move conversations toward changing our statutory structure here. I also wanted to be also very clear about the procedures that are laid out in this bill, Majority Leader. The pretrial hearing is discretionary. It's only required if the parties consent. And so in these cases, especially where the DAs are saying, we tend to agree with you, perhaps we could do that hearing together and have it happen. But otherwise, if we're the only ones asking for the ID hearing to happen pre-trial, it's going to be up to the judge whether that happens at that stage or not. And that's at line 20. It's not a guarantee.
Later illustration.
Thank you, but ma'am, it doesn't have to be by consent, right? Because of line 20, it could be.
The judge could have it, but it doesn't. The only way that a pretrial hearing is necessarily going to happen on the defendant's motion is if the state agrees to it. Otherwise, it's completely up to the judge, and they could say no.
Okay.
So even in a case where a defense, where ID is part of the client's story, we may not get to tell it until sentencing.
Okay. Well, yeah. I mean, but the defense attorney could file the motion, the court could set the hearing, and the state may not agree with that.
That's
but
right.
That would still take place pre-trial. Okay.
It would. Sure.
So it could happen without consent of the state.
Yes, sir. It certainly could.
And if I may, Mr. Chairman, I'm sorry, and I don't want to interrupt your testimony, but I just had a question here. It sounds, what I just heard is that there's a separate determination by a jury as to whether ID is in play, and that same determination is being made pre-trial by the court, and potentially, right, if the court agrees to hear that. And so is that a duplicate? It sounds like right now we do not have those separate determinations being required in existing law, and either by the jury or in the pretrial hearing. Do you believe that both of those fact determinations are necessary, both by the court and the jury, with what District Attorney just covered, and the way that could lead to additional time until disposition of the case?
It's interesting. Prior to today, a lot of the testimony we've heard from the state is that we should trust the jury over the judge in these cases. And so to come and now say we want to take a decision away from the jury because it potentially might cause some protraction in what we all know is very protected litigation anyway, is a little difficult to hear. I do think it's worth having both, even if we lose at the front end, I do think it's worth having the other one. And I think several of you were not here when Mr. Admiran from the Southern Center testified, and I want to just review one set of statistics that he offered, and that is in 2015, I believe is the year, we saw 300,000 cases in the Department of Corrections. Am I say it right?
That's since 2015.
Since 2015. 300,000 prosecutions resulting in, and then 150, sorry, I'm mixing up my numbers, 150,000, 3,000 of those were homicides. 90 of those were death penalty cases, and in only 10 over the past 10 years has someone raised an ID claim. And I mentioned the subcommittee hearing, even today, it's representative of our current death row population. We have, I want to say, 34 people that are living on death row in Georgia, and of those, 5 raised ID claims at trial. So we are talking about a small universe of cases.
Thank you. Thank you, Chairman.
Thank you.
Another bit, and I believe this might go to your questions, Representative Leverett. I was just trying to decide if you're a chairman. I'm sorry, my brain was ticking through. Chairman Leverett. And not to put words in your mouth, but I think part of what you were asking is, can there be limitations on mitigation evidence?
Well, not that specific, just can there be limitations on the number of times when a defendant can raise the issue of intellectual disability?
So I'm going to, because the court has said in Lockett, this is the Supreme Court of the United States, that we prefer individualized sentencing determinations, especially in death penalty cases, that the legislature and the courts cannot limit mitigation evidence. And when you couple that with the case law that says a jury may consider any evidence as mitigation that the juror finds relevant, essentially, I think the answer is you can't ever prevent it. If there's an opportunity for the information to get before the jury, you can bring it up. I mean, you could get into evidentiary issues around whether it's, cumulative or, those types of things. But as far as like the opportunity to raise it, I believe you can.
Well, I appreciate you. That was the question I was trying to ask. And I guess my question, sort of follow up to that, is the issue you cannot preclude it from being raised a second time during sentencing, or if it's decided by a judge in a pretrial hearing structured precisely for the purpose of not injecting that issue into the guilt or innocence phase because I think it's considered to be prejudicial, could you preclude relitigation of that issue in a guilt or innocence phase constitutionally?
I don't know the answer to that. I don't know if that's gone up on appeal because of the different structures of the way death penalty statutes are framed in the country.
I'm good at asking the questions. I'm not good at answering them myself. So thank you. I understand exactly, especially when it comes to answering legal questions about what the constitutionality of a criminal procedure is. So well, thank you. And I had it had seemed to me that and even the state earlier was, at the last hearing, was sort of allowing, it could be raised in mitigation, I think was the phrase they were using.
That's right.
It just seemed unfair to me to set up a structure where you would have that determined at the beginning, before you even impanel a jury, and make the state sort of potentially be foreclosed from ever raising the issue again, but not the defense. And I suppose the answer may be, well, the defendant's the one whose life is on the line, so they ought to be able to raise it as many times as they possibly can.
And that lines up with the case law and sentencing evidence,
Yes.
certainly.
Yes. Okay. Thank you. Thank you, Mr. Chairman.
And the only other thing I'd just like to add is just to bear in mind that we're talking a lot about what the defendant gets to put up in mitigation. We are met with the full force of the state bringing evidence in aggravation. This is not, there's nothing about these proceedings that lacks the adversarial process that we're used to. And it is extensive what can be brought in aggravation as well. I mean, so,
And by that meaning just to counter the mitigation or...
right, to explain why the state believes death is warranted. We're not the only ones telling those stories.
I believe Mike can answer this question. We can go first. Where you at?
Do you need me?
I mean, are you satisfied, or do you need a further explanation? Okay, all right. Right. All right. Okay.
Thank
No, I might have a retirement gig there, Judge Leverett. Okay, Elizabeth Hapley.
Mr. Chairman, members of the committee, I represent the Georgians for Alternatives to the Death Penalty, and we just wanted to express our thanks to the author for bringing the bill and the chairman and the committee for hearing the bill and deliberating, and we support it.
Your discretion and brevity is appreciated. All right. Number 3, Chairman Crow made it through public safety and made it here.
Well, and I was just going to say that I would have appreciated Elizabeth's brevity in my committee earlier. I would have been here sooner. So I'm just playing. Thank you.
She's a little hoarse from your
Chairman Workheiser.
Is that everybody?
That's
Okay.
all I
want
have.
to make a couple of comments, and that is, it's interesting that it was said that this bill was brought because of the Rodney Young case, and this is the first time I've mentioned his name. It is not why I've brought this case. But if you want to answer the question, have we executed someone with ID? Borderline lights. I remember the date, March 30th, 2024, because it was sine die, and I was when it happened. IQ 768, so borderline, but not so borderline. 2015, Warren Hill. There was no question that the guy had intellectual disability. Both sides agreed that he was intellectually disabled. But the question before the Supreme Court was, do we execute him? Because in the 2002 decision of Atkins versus Virginia, which became Virginia versus USA, who said you cannot execute someone with intellectual disability because it violates the 8th Amendment of cruel and unusual punishment, but that will be left up to the states. So immediately, Virginia, Texas, and Florida changed their law. Georgia did not. And so the question before the Georgia Supreme Court, it's fairly recent, 2015, since I've been elected, it was a very split decision, 4-3. And the 3 referred to the U.S. Supreme Court, and the 4 said, but we've got to follow the Georgia law. And I'm going to quote this in layman terms, but that Supreme Court justice, who every one of you know, said, until the legislature fixes this, we have no choice, and voted to execute Warren Hill in 2015. So it has happened. It is rare because these cases are rare. So we are spending a lot of time on something that happens probably once every 7 or 10 years. So since it is rare, it's an easy fix. We're the only state that does this. I would ask that we fix this and let's send it on to the Senate. Thank you.
Thank you. All right, that's all we have. Majority Leader F. Street.
Motion do pass.
Motion a second do pass on LC 48-1378. Any other further discussion? Seeing none, all those in favor of passage of the bill say aye. Aye. All those opposed, same sign. Congratulations, you're on the rules. Okay, we are going to take a brief restroom break. We'll be back in 5 minutes.
Thank y'all.
All right, let's come back to order. Let's come back to order. All right, come on, everybody. Sooner you sit down, the sooner we can get to going. All right, we are back on House Bill 171. We heard testimony. I don't have anybody signed up. Any questions, Chairwoman Silcox?
At the appropriate time.
Thank you. Don't get on the elevator over here.
Yes, yes.
Chairwoman Silcox got stuff. All right. I've got a motion from second. Any discussion? No amendments. All in favor?
Do you want to add your amendment?
Hold, I've rescinded. Hold on. Y'all jumped the gun on me. Okay.
It'll be right here, line 58.
We are actually going to insert that language before the word Georgia Bureau of Investigation on line 58. We thought statutorily that would read better. And what we would be inserting in front of Georgia would be National Center for Missing or Exploited Children.
In addition to, though.
In addition to the.
And then I would start at Georgia.
So. All right, I got a motion second on the Smith Amendment. All those in favor say aye.
Aye.
All those opposed, same sign. All right, it's on. All right. Seeing no other and hearing no other amendments, all those in favor of the passage of the House Bill 171 LC 48-1500S with the Smith Amendment, say aye. Aye. All those opposed, same sign. Congratulations, you're on the rules. Okay. Okay, thank you. All right. Chairman Blackman, Chairman Blackman, House Bill 222. Assume the chair. Welcome.
Thank you. I don't get over here very often. I appreciate you hearing this bill bring before you and the committee, House Bill 222, which was really brought to my attention by our county clerk, Teresa Hathaway, and I think it's intended to help communication and between the courts and some of these individuals when it comes to these bonds. And I really submit to the wisdom of the committee, since I don't know your matter of expertise. I don't have your wisdom and expertise on these issues, but in the hopes that we may be able to do something to help them.
Seemed fairly straightforward to myself and others on discussion of this. Are we going to get the same kind of brief treatment in Ways and Means? That's what I want to know.
You mean after that last hour of delay?
Right. From a practitioner standpoint, and I think the prosecutors would agree, when I was still taking appointed cases, trying to find clients and keep up with the addresses, I mean, they could still change their place of abode, but this surely helps all parties involved. So I don't think I have anybody signed up on this legislation to speak or testify. Number 17.
Just ready to make a motion.
I'll entertain it. Move to pass second. All those in favor say aye. Aye. All those opposed, same sign. You're close to the record for closest or fastest pass.
I am grateful, Mr. Chairman, to you and members of the committee. Thank you very much. If you don't mind a little bit of joking and banter there, but
thank you.
Yeah, I know y'all had a rough, a busy schedule here, so thanks for adding me.
Thank you. I'll sign that form whenever you get it to me, Chairman. Yes, sir. All right, next we have Representative Fleming, Tim Fleming, House Bill 390, the HALO Act. First of all, what another acronym that I have to keep up with in my practice. What's HALO stand for?
What is the exact terminology? Mr. Chairman, this is Ken Davis from Fraternal Order of Police.
Good afternoon. It's actually not an acronym, which should please you. It's just the idea of a halo. It's designed to provide a safety buffer for public safety workers, and as if you would, a halo. So that would be the source of the name.
And I don't know if you knew this, Representative Fleming, but your guest witness is John Marshall, class of 2016, valedictorian of the part-time program.
He told me he was in the class with you. So.
Yes,
sir.
and valedictorian. Go ahead.
Thank you, Mr. Chairman. Yeah, so this House Bill 390, the HALO Act, was actually brought to my attention a few months ago by one of my local police chiefs, and then I worked with the FOP on drafting this. We crafted it after the state of Florida, which just enacted the law back first of the year. Several other states have done the same thing. It's pretty simple. What it does is it enacts a 25-foot perimeter around public safety personnel when they are on an active scene or emergency, to keep people 25 feet away from them so they can perform their duties, their official duties, which pertains to any first responder, law enforcement, paramedics, firefighters. There first will be a verbal warning, and then if they refuse to acknowledge that and continue to impede or interfere with the first responder's ability to perform that duty, or threaten the first responder, or for the physical harm, or harass that first responder, if the person is convicted, they shall be guilty of misdemeanor of high and aggravated nature. And so that's simple, pretty much what it does to the point. It is endorsed, like I said, by the FOP and a lot of other first responders across the state.
Okay. Number 13, Majority Leader Abstration.
Thank you very much, Mr. Chairman. Representative, thank you very much for bringing this bill. I think first responders who are responding in difficult situations, they often need to be given room, space to work, don't need to be interfered with. I completely understand and agree with the purpose behind this. So and I apologize, I wasn't in subcommittee before, so I just had a very specific question reading your bill in advance of today. So it looks like the bases, the third is line 31, but the third way is harass the first responder, and then harass is defined, the definition's provided here. And I certainly understand the first two, impede or interfere, or threaten the first responder with physical harm. But I guess what I'm thinking is sometimes when there are victims who are there present, you've just endured a very traumatic experience that's just happened. Maybe they're frantic. Maybe it's a family member has just been hurt or is suffering a medical emergency. Is there any concern that this harass definition, which would cause a first offender, intentionally causes substantial emotional distress and serves no legitimate purpose? That may just be somebody's just being irate because of what's going on. They really don't. It doesn't have the criminal intent that I generally think of that would go into being the mentality for a mens rea for a crime.
Right. And if I can, Mr. Davis.
So, yes, please. And thank you for the recognition from the chair. It's good to see you, sir. In looking at this, if you look at that definition of harass, and if I get where you're coming from, and I think I do, right? There's this concern over, is it because somebody's upset, and is it words that they say? But if you look at the actual language of this harass means to knowingly and willfully engage in any conduct. So there has to be some actual conduct there. This is not just words that someone says. This is conduct that they engage in.
Well, Mr. Chairman, if I may, one final question. So I guess that conduct is really what I'm getting at. If they are just acting very outside of their nature because of the trauma they've just observed or endured, and the test here is it causing the first responder substantial emotional distress, and serves no legitimate purpose. I think serves no legitimate purpose in my hypothetical is clear. It's just due to the emotional nature of what's occurred. But then the determinative factor is it causing the first responder emotional distress, which could, I imagine, have like a varying degree of what would cause that first responder emotional distress or not. I think really what I'm getting at is that going to be so broad an application that it would capture folks that we ordinarily would not consider necessarily trying to interfere with the first responder's work. They're just they've just been a victim of a lot of trauma and just observed something terrible.
Right. Now, and I understand, and you got to recognize also that for that conduct to be criminal, first off, as I mentioned a moment ago, there must actually be conduct, but it's also after they have ignored this direction from the first responder, to stay out of this buffer zone. So there's an opportunity for them to hear what's going on ahead of this, right? And part of the statute also says that they knowingly and willfully engage in that conduct. Could those issues be raised in a criminal defense at some point? They could be, and I think our courts are very well versed in parsing that out if that's an issue.
Thank you.
Let's see, number 11, Chairwoman Silcox.
Thank you, Mr. Chairman. So just to follow up to the majority leader, I just would say, there are people that homeless on psychotropic drugs that, would be out of line regardless, and they may not even consciously hear the direction. And so I agree with him that there may be circumstances that are extenuating. And I guess they could assert that as a defense in court, like you're saying. Maybe they have an intellectual disability. Maybe they've been diagnosed as psychotic. There's all these things. I guess they could assert as a defense.
Yes, ma'am. But I would add to that. There's also provisions under the Georgia Code that permits a peace officer to engage in a process where they can do an involuntary committal against a subject. And right now, the way that law stands in Georgia, there has to be some penal violation. So they could certainly take the fact that this statute's been violated, and instead of taking this person to jail, go through that process of committal if there's a mental health issue.
Great. Okay, thank you.
Yes.
All right, number 7, Representative Panich.
Thank you. And I agree with the intent to protect first responders. My question is, how is this different from an obstruction against a firefighter or police officer or park ranger? We have statutes for those.
We do, and I think that's a fair point, but my response to that would be, when you charge obstruction, and by the way, I have a background in law enforcement. I spent nearly 30 years in law enforcement before I became a lawyer, and those crimes, those happen after the fact, right? So for an obstruction to happen, the obstruction happens, then there's a charge. This is more preventative in nature. This gives that buffer zone around the officer to hopefully prevent an obstruction from happening. It gives an opportunity for the officer to short circuit that, so to speak, in a different way. So are there other statutes that could apply? They do, but they're after the fact. This is more preventative. One of the things that we teach officers, and I'm speaking from a law enforcement perspective because that's my background, is that space is reaction time, right? It's called a reactionary gap. That's the way officers refer to it and the way trainers refer to it. And by having this reactionary gap built into the statute, then you're going to help prevent those situations from happening. Certainly they may still happen, and if they do, you can enforce this law, you can enforce the obstruction statutes as well. But that's how I would distinguish those.
Thank you.
Yes.
Number 14, Representative Holly.
Thank you, Mr. Chairman. Thank you for your work in the line of duty, your understanding a lot of the troubles for our first responders to be able to do their job if they're being impeded. I'm just kind of curious. I know for RC4 that where you're intending to define what that interference might be. I know a line 28, you're saying that you literally are defining the perimeter of the 25 feet. Do you know, is there a directive in the law for law enforcement officers or first responders to actually inform the victim, for the would-be defendant that they need to actually keep back 25 feet?
Sure. So the statute itself does note that the public safety person must give the direction that they're to be back. Now, it does not specify that they're supposed to state that limit. However, I would say to you that the officer involved, if they're not back far enough, can simply repeat, their notice, right? Mm-hmm. So, but it does not say that they must say you have to be back 25 feet, and is somebody going to be able to recognize that anyway? Probably not. But this gives them that space and that latitude to create that space. And then if they don't do so, and then they take other action with these other specific intents, then they can act in response to it.
Okay, because I think, and I'm glad that you specified to me. I'm just kind of curious because of that. If it gives the first responder enough latitude for that 25 feet, then I think that in the case that Chairman Estration mentioned, just in terms of having to conclude their mens rea that there isn't a desire to potentially cause harm or to harass, right? If the person who has the responsibility of making sure that they are not impeding upon a duty of a first responder, if they are not given that latitude to know of how far in terms of a distance, like we're thinking of like a very emotional parent who's seen their child get arrested. If they're not aware of that, then whether they are 10 feet or 15 feet away, they still, even after hearing maybe the first or second call to stand back, they still may be in violation of the law enough to actually be arrested.
Well, and that could be, right? But under the spirit of the law, would an officer actually do that? I don't know. I can't tell you that any more than anybody else here could. But what I can tell you is, as it would progress through any kind of prosecution, for there to be a conviction, just like any other element of any criminal law, it would have to be proven that in fact was what happened. And if that's not the case, then there's no conviction.
Gotcha. So they would have to get a charge first and then go to court and then fight it in court.
That is true. That's what our courts do. They determine whether or not somebody's culpable for a criminal act or not.
All right, number 2. Is that Chairman Crow?
That's me.
Oh, Chairman Gullett.
Yeah, thank you. Thank you for the bill. Public safety is something I've worked really hard to support a long time. I do think that the leader touched on the harassment part that really stuck with me. And like, what would be harassment that causes substantial emotional distress that really didn't impede on interfering with the first responder's ability to perform such duty? Like, what would be there that wouldn't be? What is harassment adding that wouldn't be caught in 1 and 2?
So as I think about that, I guess part of the reason that that's there, and I will tell you, this was also modeled pretty closely on Florida's statute that's been enacted, and they have the same definition. But as I read that and I think about it, it is a bit of a catch-all, and I think my not thinking of an example right now is exactly why it needs to be there, because there certainly can be an act that has that effect that is unlawful, that is out of the ordinary, right? It's not something that we can sit and particularize and put in a statute. And having this in the statute kind of allows for that outlier conduct that is harassing, that would have that result on a peace officer, that you may not can shoehorn into any of these other provisions.
Yeah, I guess I think opposite. I think by not having an idea of what that is, instead of having a catch-all where there's, if someone has gone through something traumatic, they just saw their kid get hit by a bus or something awful, right? Sure. And you're out of mind crazy. I mean, because that would happen to me. I don't know what would happen. And they're, paramedics are on scene, step back. I need you to, I'm sitting there looking at my kid. Like, if I wasn't impeding or interfering with it, like, I'm just trying to think of what would cause substantial emotional distress to someone in law enforcement or in public safety that's not interfering or impeding with the first responder. And words, you said it's got to be more than words, and so I'm just trying to think of what it would be, me throwing a water bottle at them or something, like, but that to me is impeding their investigation, their whatever that is. I'm just trying to think what that could be, and does it really add value, or does it just really, if you're caught in that and then you do get arrested for it, God forbid, then you have to, the court is the place to deal with that, but that's also, it can be very costly. It can go bad also. I want to protect our public safety 100%, and I want to make sure they can do their job. But I also don't want to, I'm just trying to think of what that could be, and I can't think of anything, and I don't know that we need, if we can't think of what that could be, why we need it.
So as you've been talking, I've been thinking,
which
is something
I
try to do. And I thought of an example.
Perfect.
For example, so I said words are not protected. There are certain words that are not protected by the First Amendment, right? For example, if I say I'm going to shoot you and kill you, That is an aggravated assault. That's not protected by the First Amendment.
Right.
That is indeed a crime. Does that fit this category of harass? I can see an officer attempting to arrest somebody and say, "That's my brother, I'm going to shoot you." Right? I can see that kind of scenario, and then that kind of conduct falls exactly into that type of definition.
But you don't think it impedes with their performance of their duty?
Well, it may not at that point if it's only words. Number 2. But it's still not lawful words. You still have an instance.
So if it's not lawful, though, I mean, you can't say it to someone regardless, right? So I'm number 2. Yeah. Yeah. Right. Or threaten. Yeah. So you got that covered because number 2, threaten.
I see. Well, that's the one that came to mind while you were
Okay,
speaking.
I got you. I understand there might not be an answer to that, but I think that's what concerns me because I'm trying to find something, and I don't want necessarily a catch-all for someone to go. I want people to leave public safety alone. I just don't know if like catch-all is really the right. What we're anything you do on a scene could potentially be caught. That's not necessarily, what we want. Even if it can be adjudicated and fixed in court, sometimes that's not really. You still are arrested. You go through more trauma potentially. I don't know, just something I'm going through, and this is tough for me because I spend a lot of time supporting public safety, making sure back home that they're taken care of. But that was a hard one for me to get through.
We appreciate that, and I understand your concerns, and I've answered it the best way I think I can.
Thank you.
All right, number 17, Chairman Leverett.
Thank you, Mr. Chairman. Thank you for the bill. I think I share a lot of the feel that this is something we need. I just have some similar questions about the different sort of alternative prongs, I guess, of it. So, as I understand the way this would work, if you are impeding or interfering or even threatening, but you're 25 feet away, you're not violating the statute.
Not this statute.
Yeah, not this one. There may be another statute, but not this one.
Yes, Chairman.
And harass, I think, is defined here in terms of the impact it has upon the first responder in making him or her upset, basically, emotional distress.
Substantial emotional distress is how it is the language that's used in the bill. Yes.
Right. And I suppose I was trying to think too, what would be an example of something that would be harassing that's not threatening or impeding or interfering? And maybe if you were upset and saying something about the abilities or capacity or knowledge of the first responder, or
attacking their ability to do the job.
Right. You don't know what you're doing. Get away from my family member. Don't touch him. Wait for the other guy who knows what he's doing to get here. Or saying something about. I won't keep going into those examples, but I guess I'm just positing if I can certainly see impede, interfere, threaten. And I don't want our first responders to be harassed either, but I sort of share the leader's concern, I guess, that sometimes these are very emotional situations, and
Indeed.
I don't want to lock folks up for just being a little overwrought at the time. And if I were a first responder, I might feel a lot differently about it. But I just thought maybe we want to comment on that.
Well,
so.
And speaking as a former first responder, I don't think so. I mean, we collectively as first responders, I'm representing the FOP here today, but I've been in that position. Our desire is also not to take someone who's in that kind of circumstance and basically put them in a worse circumstance. That's not the goal of the bill at all. The goal of the bill is to provide that safety buffer. We certainly understand. I understand. I've seen it on the scene, on many scenes over the years, where you have somebody that's upset, and there's alternate means for dealing with that. This doesn't mean that they're going to go to jail necessarily. It requires a level of conduct beyond being upset.
Well, and I suppose too, again, I can harass the first responder as long as I'm 25 feet away, right?
I believe that would probably be correct. Yes, sir.
Okay. All right. All right. Thank you.
Thank you.
All right, that's all the questions I have. If y'all want to scoot over, I'm going to call on the witness from the crowd. Need Pack. There's a question circulating, and we want to put it to bed. I mean, is there a rule of lenity issue present here?
I'll send legal counsel on that.
Smart man.
Only because Robert Smith from PAC, and only because I want I want immunity for what I'm about to say from the chair, because
total immunity.
The leader has expressed to me many times about his love of the rule of lenity, and I do not want to catch his ire because he's a great man. The rule of lenity. You warned me one time when I appeared before not to discuss the rule of lenity. Oh, did I? Yes, sir. In my bill.
Don't talk about the problems with the bill.
The rule of lenity works this way: if you have if you have a crime listed two different ways with two different punishments. How it works is that you have the same conduct punished two different ways, two different punishments. The lesser punishment is the one that controls. So in this instance, this bill purports to create a high and aggravated misdemeanor. Things like obstruction, disorderly conduct, those are misdemeanors unless you do something to aggravate it. Same thing with terroristic threats. Those are all misdemeanors. There's an argument that could be made that a high and aggravated misdemeanor versus a misdemeanor, it really, what the difference is good time credit, bond conditions, maximum fine. But still, there is inherently a difference in how these two things would be punished for essentially what could be argued to be the same conduct. Is that a really long answer that actually is an answer?
Majority Leader.
So, thank you, Mr. Chairman. So, Mr. Smith, if I understand you, theoretically, there could be a circumstance where somebody threatens the first responder with physical harm, which is offering violence, which is captured under the felony charge of obstruction of a law enforcement officer, and because that occurred within the 25 feet and all the rest, the elements of both offenses would be satisfied, and they could argue, no, you can't charge me with felony obstruction. I'm to be charged with high and aggravated misdemeanor under this statute. Do I understand you?
If they offer or do violence to the person of a firefighter or other first responder who's covered in one of those obstructions, yes. Okay. You would then have a problem between the two statutes. Same conduct.
Is this fixable here where we can because I think this is a very different kind of area we're trying to address, which is having a safe scene for first responders to do you think that we can figure this out so that we don't have that overlap?
I think there is a way. There always is a way. I mean, that's, there always is. Just it depends on the words that can be found.
Yes, sir. Thank you.
Looks like I'm going to sign homework. So,
can I be excused?
You can be excused.
You said homework. I'm getting out of the way.
I know. I don't know how much power I have. My bailiff left. All right. What I'm going to do, there's some concerns. I'll work with the bill author, and we'll get this hashed out. I think there's a path forward.
Yes, sir.
Thank y'all. Always good to see a classmate. Thank y'all for being here. Okay, last but not least, House Bill 176.
Wait, so we have two left.
Oh, two, I'm sorry. I apologize, Ed. All right. Okay, we'll let Representative Panich go first. House Bill 460. You can present from right there where you're at, just so we don't play musical chairs. House Bill 460. Representative Panich.
Thank you, Mr. Chairman. This is the bill we were here on yesterday late afternoon for those of you who were on the subcommittee. For those who were not, This is a bill to prevent the recording of conversations between lawyers and their clients who are in custody in a penal institution, which includes jails and prisons in Georgia. The questions yesterday, well, this is one of those things you already thought wasn't legal, but surprise. So we want to make sure that it's, that the privilege and the confidentiality between a lawyer and their client in a penal institution is protected. And that's what this does. I'm happy to answer any questions. There was a question yesterday about how it would impact the local jails and the prisons. And I think Terry from the Sheriff's Association had spoken to some of you to indicate that he believes the technology is already there. So because during the pandemic, there was a lot of added technology to the jails and prisons related to visitation, electronic visitation or phone calls. So he checked with one of the providers and was told that the technology was there already.
I can attest to that. I spoke with Terry earlier. Most of the vendors do have this capability to implement this if passed. I think there was only one vendor that did not, so that was what I understood from him. I have number 6 lighting up. I think somebody may have.
Oh, I may have pushed it by accident.
All right. Any questions for the bill author? Okay, I do not see any. I don't have anyone signed up for this. Number 3, Chairman Crow.
Yeah, I did actually. Your bailiff. I spoke with him before he absconded, and yeah, he did indicate that the capability is there now, so the attorney would simply need to contact that provider and go through a vetting process and add their number, and then anytime their client calls that particular number, that those are not recorded. So that seems like that may be able to be fixed now, so it's already a solution. I don't know if we need to. My only concern still with this, and I appreciate the author getting me the answer on that. The only concern I have now is that the way it's written, if it's going to require another phone or procedure to be put in place, if that makes sense. So, trying to get back to it, sorry. If I can get to my
I
bill.
think
It says to a non-recording telephonic or electronic device. And so that solution does not meet the definition here, because it is not a non-recording telephonic device.
Again, from conversation with Terry earlier, he indicated that from their standpoint with these vendors, they do not record that conversation. They just show where the call was made, which I don't think any attorney would object to that being on the record of the call being made.
So having a recording telephonic device that you can just opt out of by registering your number, that would meet the definition of this. That wouldn't be in violation of this. That's my concern. Sometimes the way these things are read, I want to make sure that there's not an issue with them using that method of solution by definition of the words on line 13 to 14, and that was my only concern. So.
Yeah, I share that concern too. But what Terry had indicated was that this would only show where the call was made. Let's see. Number 13, letter illustration.
Thank you, Mr. Chairman. Representative Panich. So, currently this communication will be included under privilege, which would exclude it from introduction already, I would assume. And I guess what I was just curious about, 2 questions here. First of all, lines 19, 20, I guess it's, this is a procedure by which, as I understand it, could be tendered. And I'm assuming this would be some sort of like wire investigation where maybe it's not known that, or maybe the attorney's participating in the criminal act. I was hoping you could just tell me about that. What and under what circumstances is this 10-day notice before trial and all that going to come in if this truly is attorney-client communication that was recorded? My second related question is, and then also there's a process here, like from line 31 on, where it appears that there's like the procedure for how the motion would be filed and all the rest. And I'm just wondering if it's truly privileged communication, is it necessary to have all that procedure in there? I mean, couldn't you raise that at any point in time or seek to exclude the evidence upon, at any point?
Well, so the privilege only prevents it from being introduced in court. And what we were hearing is that the prosecutors have access to listen to the call and just not use it in court. Now, I'm not saying a lot of prosecutors do that, but they certainly have the capability because it's recorded. So this is to prevent the recording at all. But we understand that there are some times if there's a lawyer who is doing something that is suspected to be criminal, then law enforcement can get a warrant if they believe that the lawyer is involved in any type of criminal activity. They have to go through a neutral magistrate and get a warrant and be able to record that call.
So, Mr. Chairman, if I may, just one follow-up question. It's my, well, I guess, is it true, am I correct in believing that no one else is supposed to listen to or use any privileged communication at any point in time, and that if you do get that, it's not to be used, you could actually be, I assumed, walled off from being involved in the case and not be able to share it? And can you just reassure me that this is not in any way, the language here, procedural language 31 on, is not going to actually erode that from being the case by putting in this procedure as to how that's to be considered by the court?
I'm not sure I'm understanding the question. This statute came out of the Burns case.
Okay.
So it was a Georgia Supreme Court case in the fall of 2024, which essentially said you have to listen to the call to determine whether it's privileged or not. It was between a lawyer and a client who was dealing with a bond issue. There was a strongly worded dissent by Justice McMillan, which essentially questioned, why do you have to listen to the call? It should be a call that's not listened to in order to determine whether there's a privilege or not. So my first thought on this was just to expand the privilege definition, but then while we were discussing it with the chair, it was clear we need to stop the recording to begin with. So unless there is a real reason that somebody can prove before a neutral magistrate that they need to record, there shouldn't be a recording. Nobody can record the call with a client who's not in custody, so they shouldn't be allowed to record the call when they are in custody.
Thank you, and I will read the Burns case, and I appreciate you explaining that. Appreciate
Here,
it.
I have a copy.
Yeah, great. Thank you.
Thank you. Yes, Majority Leader, I made the remark yesterday in subcommittee that when I read that case, I almost went through the roof with how aggravated I was at the determination. I share your same opinion that I know Judge F. Strach and Judge Smith, most of the judges here would read and understand that to be privileged communication, but I'm not going to say anything further about across the street from here on out. The University of Georgia, as much as we love them, they can still shank a pun every now and then. So
I don't know what he just said. What did he? I heard the word shank. Oh, sorry.
All right.
Football.
I think that's
Go Dogs.
That's all I had. That's all I see on the board. Number 4, Representative
I was
Rowe.
just going to make a motion when you're ready.
Okay, I'll entertain the motion.
Motion do pass.
Motion to pass and second. Any discussion or amendments? Seeing none, all those in favor? All those opposed? All right, you're on the rules. Okay.
Sorry, look away.
Okay, I'll be very brief. This is House Bill 176. I'll present from here, and if I'll let Representative Hong take over since she's closest to me. Okay, this is a bill that we had before us. This is the version we finally were able to get over to the Senate, and unfortunately the Senate printer had a little lag time last session. I had everything from, there were rumors that abounded as to why the bill wasn't brought to the Senate floor and voted on. My pretty doggone clear understanding is it didn't get a vote in the Senate because the printer was backed up in 2024, but alas. Just to basically go over what the bill accomplishes. This comes from the two cases. You had the Seals versus State dealing with dead docket and the entanglement there, and you also had the Cook versus State with appeal access tangle. And so this basically reinstates the meaningful access to request post-conviction review from the court. It would also untangle withdrawal of the guilty plea. It's a very convoluted process that's influenced greatly by case law from the courts, and so this streamlines it. I think I've had 3 or 4 Superior Court judges over the interim between last session and this session bring this up about this creating clarity in our process here in the state. So this would allow the motion to withdraw a guilty plea to be within the term of court or 30 days, whichever occurs last. And so affording them that opportunity, a clear opportunity to also withdraw your guilty plea. So that's the crux of the matter. And I know we've got one person signed up. I'll take questions first. Y'all can ask questions. All right, I see none. I have one person signed up to speak against. Randy McGinley.
I'll be brief. Randy McGinley, DA, the Alcovey Circuit. In general, the idea, I think I've always been supportive of the idea of doing something to fix Cook. Let's put it that way. I'm a firm believer that prosecutors prosecute cases, and if we try a case, 100% believe the person's guilty, go forward on the case, and they have a right to appeal the case. And we're going to vigorously defend our appeal or our conviction, but they have that right to appeal it. My only concern is lines 48 through 54 is some of these issues when Cook came about, the only issue they really had was defendants had the ability to file a habeas because their attorney missed the deadline. My only concern is, does this automatically give that person another, if they say they filed a habeas since Cook and now and already addressed all these issues in habeas, does this give them an automatic right to file another motion for trial after they had a habeas and basically have another bite of the apple when they've already had those issues dealt with on habeas? That's my only concern. The rest of the bill, fully support. I guess put it that way. So.
Thank you. In rebuttal, anyone from Gactal want to come up? Amazingly.
Be happy to.
Yeah, come on up.
Give me a.
Y'all don't elbow each other. Just kidding.
That would be a
I'm just
battery
kidding.
and some kind of other
Go
construction, right? So since the Cook case came down in 2022, it is true that the remedy that's been available to many people simply is habeas because they've been procedurally barred from filing these out-of-time motions for new trials and appeals. So it is not surprising that there is going to be some cohort of people that have tried that. And the good news about the bill, well, 2 pieces of good news. One is I did speak with PAC ahead of the hearing, and my understanding would be that we'd agree there's not a large number of people that this is likely to include. You don't have a right to counsel on habeas. So you either have to have hired someone to do that for you or be sophisticated enough to do it yourself. And it was, like I said, it was 22. In fact, I think the decision was in March of 22, so we're just about 2 years out. But even still, however many people that this does impact, the right to this new hearing is also discretionary. So when the court, if you, in lines 31 through 40, it explains that this is just a gatekeeping opportunity to get back into court on these out-of-time matters. And so if, for instance, you, in a case where there's been a habeas, let's say, success, and the person still wants to try for a new trial, you're probably not going to get the consent of the state. You may have one of the other factors, but then the court is going to receive evidence, and she might decide, sorry, no, you know, you've had a chance, you had success, I'm not going to give you another opportunity. But depending on the facts of the case and the circumstances, she might say yes. I mean, so it is possible that there will be people, as the DA has described, that would, well, let me say it this way. If Cook had not been overturned, these same people would have these same 2 bites, because they would have the opportunity to pursue their out-of-time appeal, and failing that, they would still have habeas rights. So it's, I'm sorry, when Cook, sorry, I misspoke.
Throughout the system.
Throughout the system, yes, thank you. Long day, tired mind and mouth. When Cook made new law, thank you. I appreciate all the assistance. I will
We'll give you some
bring you some more Girl Scout cookies later. Yes, so that's okay. It's all right, it's all right. But I'd love to get it back. Oh, so they would have still had 2 opportunities. I mean, it's 2 opportunities. They may be getting them in reverse this time, but it would not have been precluded had they gone through their motion for new trial first and then had to seek habeas later.
Number 14, Representative Holly.
Thank you, Mr. Chairman. So, and I apologize, I'm not an attorney.
You don't need to apologize for that. A lot of people think that's admirable.
But I guess if this were in this new form to go and pass, it's actually kind of dealing with the possibility of like an ineffective assistance of counsel, if you know, in this habeas corpus, because the defendant he's serving a sentence out, he or she's serving a sentence out, and you know, they may have had an attorney who just missed the deadline completely. This puts them back in the same place where now the defendant will still be able to go and actually file and just to get so that this case would be under a review while they're still incarcerated.
That's right.
Okay, thank you.
Seeing no others, thank you.
Thank you.
All right. I think that's all I had signed up to speak. Yes, Chairman Crow.
I was reading, also non-lawyer. So, but the way I read that paragraph B that DA McGinley was talking about, so this would only apply to those who had those motions dismissed based on Cook.
That's right.
And they only have until June 30th of this year
to
file based on this.
Based on this, but I'm hoping there will be an amendment that will put that out 1 year, because as the chairman said, this is exactly the conference committee report from 2024. So that 2025 date is based on that session's timelines. I mean, I don't know with certainty whether this body would pass that amendment, but that's our hope. Is that
to my question? That's why I thought that's not a big deal. It's probably won't even go into law until July 1st, so we'll be okay. Okay. I was just curious how many of those out-of-time motions may have been dismissed based upon Cook. I'm just trying to get a number about how many there might be that would get another bite at the apple, so to speak.
I don't know that. I don't know that number.
Okay. Thank you.
I think based on the 2025 language, I'd entertain moving that to 26. That gives both sides at least a year to deal with that, handle that appeal, both prosecutor and defense. I think it'd be fair. If the governor signed it into law, that is, assuming. So I'd welcome the amendment. Okay, I see no other
Thank you.
questions. Thank you. What say the committee?
Move to pass. Second.
Got to move to pass in a second.
Is this for the, this for the amendment, right?
This for the bill. We have, so everybody remember, we have to have a motion to pass the bill before we can entertain amendments. Number 2. So I got a motion and a second to pass. Number 2, Chairman Gullett.
I move that we strike 2025 from 52 and make it 2026.
Okay. Got a moving second on the Gullett amendment to strike 2025 in line 52, and I believe that's the only section we would need to change.
Sorry, what I saw.
Yep. Moving second on the Gullett amendment. All those in favor say aye.
Aye.
Those opposed, same sign. Okay. Gullett amendments on. All those in favor of the passage of LC 481365 with the Gullett amendment say aye.
Aye.
All those opposed, same sign. All right. Thank you. Yes.
I apologize. I'm probably totally out of line. 242 was advertised too, but y'all haven't said anything about that.
Yes, we are coming to that. We're coming to that. Thank you, Mr. Attorney General Emeritus. All right. I apologize. I meant to go last. All right. House Bill 242, and I can give Rep. Oh. We don't have that one.
I could have made copies.
You want me to make them real quick? Or?
It's not on the agenda either.
I know. It wasn't, we didn't, I didn't.
I know. I just. Okay. You tell me whatever you want to do.
I may be at risk of losing the quorum, but if that back, you'll make copies real quick. We'll suspend for a minute. The Senate goes until 9 o'clock, 10 o'clock at night. I don't know why the House can't.
We don't want to be like the city.
I know.
I want to be here till 9 or 10 o'clock either.
There's concern that
I wouldn't get things moving. Good use of your time to actually like help. These are the Aussies. Okay, I'll get it. It's Costco's right by the house, so it's like it's, they're very helpful.
So it's one of the that help common and the representatives.
It's not on the agenda, it's on the website.
We're now being handed the substitute to House Bill 242. I'm going to call on Representative Hong as to what changes were made in subcommittee yesterday.
Thank you, Mr. Chairman. We went ahead and added just a comma on line 11 after observance and a comma on line 19 after observance. That's the only change that we've made.
Okay, thank you. Chairwoman Silcox, if you just want to briefly tell us what this bill accomplishes.
Sure. Yeah, this is really just to bring attention to the fact that there has been a group, unfortunately, that has most recently, they were protesting during a religious service at a synagogue in East Cobb, and it has happened in different places around the nation, unfortunately. And so this is really just to say that, you know, that you cannot intentionally impede, disrupt, disturb, or interfere with the conduct of a religious service or observance or a funeral. And it's unreal to me that we have to put this in writing, but this is what's going on in our country. So would appreciate your support.
Chairwoman Silcox, this is not limited to just one faith either.
No, this is all faiths. So this would help at any mosque, synagogue, temple, church, all the above.
Okay, so if I wanted to go protest the Jedi gathering,
correct,
down at, or you know, over at Hayhira, I could still do that?
Yes.
As long as I didn't have the intent to intimidate.
Correct, yeah, because this is not a First Amendment thing because you do have to prove intent.
Okay, no offense to any of the Jedi and Hayhira. All right. Any questions from members of the committee? Number 14, Representative Holly.
Yes, sir. Is this not currently against the law? I mean, it's not.
It's just not spelled out.
Okay.
It should be. Well, funeral and memorial services, but not the ones that are private.
Okay.
Would you repeat that?
I'll be corrected if I'm wrong, but right now it's a funeral or memorial service to disrupt is a crime. It's disorderly conduct or disruptive conduct, but this adds in religious worship or observance to it.
That's why it's underlined a little. Is it like a church service or a?
Yeah.
This covers all faiths, pagan, Gentile. Number 17.
Mr. Chairman, I don't have any questions about the bill. I do have a number of questions about the whoever it is down in Hayhira, but I'll take those up with you afterwards. But I'm prepared to make a motion at the appropriate time.
Okay, I'll entertain that motion now.
Move to pass.
There you go. Move to pass second. All those in favor say aye. Aye. Those opposed? Aye. All right. It passes. You're on the rules. We are adjourned.